Hey, Corey, I'm Senator Jedediah Hinkle, also represent a portion of Gallatin County, and I'm a little fuzzy on whose water right or water use right this currently is. And I know you did make a statement that, assuming the compact is passed, then it would be a tribal water right held in trust by the federal government, which I assume is essentially a federal water right. Is that the case now? Are these water rights held in trust by the federal government currently?
So right now, no one knows. Right now, the Bureau of Indian Affairs has filed claims on these water rights prior to the deadline. By law, the tribe is not required to file the claims until this coming July. So when they file their claims, they're probably going to claim ownership. The irrigators, through their irrigation districts, have filed claims. All that stuff's been, obviously, we talked about, stayed. So that's the unanswered question. No one knows. So in terms of what it would be in the future, if it's a federal water right held in trust for the tribe, then it's what we've talked about before, a federal-based water right, because of the reservation of that right under the Winters Doctrine as part of the United States plenary authority over Indian policy. Does that answer it at all?
So basically right now it's nebulous, but it would be established a federal, held in trust, essentially federal water right after this compact is passed. That's what I'm understanding.
It would be, except that this compact's different from the last compact. So yes, that's right, but that's not the final answer. This compact is different from the last one because the last one required the irrigators to not pursue their claims. In fact, dismiss their claims of ownership of the project. This one doesn't do that. So what I expect to happen is the irrigators will pursue their claims of ownership of the project water right. And you know, who knows what journey that will take. But ultimately, let's say hypothetically, the court agrees and says, yes, you are co-owners of this project water right. It's not going to be identical. They're not going to have an 1855 water right with all these guarantees against being called off for fisheries. They'll have a, say, 1904, 1908, 1910, 1915, whenever they put that water to beneficial use through the project, improved it up, and there may be multiple dates within those. Those will be those dates. And they'll be at whatever level they've proved. Or they'll have proved that they got it through the project by agreeing with the federal implementation that created the project, and that'll all be decided. So they might have a uniform date, who knows. The point is, they'll have no earlier than a 1904 date with no guarantee from being called off to support fisheries. Or they can agree to take this project water right through this federal delivery entitlement and have a better deal than they'll ever get through litigation and asserting ownership. That's really the logic. When I talked about at the very beginning, the dilemma I faced, that was the resolution of the dilemma and the logic of why it made sense to support this compact.
Okay. I mean, it's a lot of information and it's hard to wrap my mind around right now, but it almost seemed like they're potentially, in a sense, more in danger of losing at least what they deemed as their historical water rights, essentially, if they couldn't prove it. And this would cause them to prove that. They would have to have specific documentation. I don't know, just my thoughts.
No, that's a good point. Under this agreement, we are now taking this next period of years to prove the use and then lock in what Melissa talked about, to lock in that consumptive use and ensure that the pumping and the supply and all those other things we talk about meet that consumptive use. And then over time, that consumptive use will remain the same. The total amount of water diverted will go down because of the efficiencies that are built in to improve the project. And that saved water goes to increase the water for the fish. Mm-hmm. That measurement's going to be on a going forward basis on this compact. If we go back to the adjudication, you're exactly right. Like every other person out there, you have to go back in time and prove with a very inadequate historical record what you used. And you know, obviously everyone's going to dispute that, and so there's going to be a fight over that. What I'm telling you is that under this compact, not everybody agrees with this. My theory is that whether they have or lose that individual claim doesn't matter so long as they can get their water through this guarantee that's in the compact. But I see Colleen up there. I'd love to have her tie into that.
I would just add that if the compact is not passed and the CSPT claims
are required to be filed. The prima facie standard that we apply in Montana means that those claims will be prima facie proof of their contents. They'll be, in a very rough sense, assumed to be correct until proven otherwise. And it's the burden on objectors to show that what's claimed is incorrect. So that's a very important standard in the Montana adjudication. It's different than a lot of other states. It's been a benefit to Montana water users, to state-based water users, in that historically, before passage of that prima facie standard in 1979, water users had to prove up all elements of their water rights. That was the standard of proof that went into effect if you went to district court prior to 1979. After that statute was passed, your statement of claim is prima facie proof of its contents, and objectors have to prove that what you filed is incorrect. The law says that Indian Reserve water rights must be treated similar to all other claims. And so prima facie applying to those claims means that if they're filed, it will be the objector's burden to show that whatever's filed is incorrect. And so, yes, all that historical information will be important and will be necessary, but it will be the objectors that will have to find that information and show that what the tribes claimed was incorrect. The standard was passed by the legislature recognizing the evidentiary challenges in trying to prove up water rights that at that time had already been in place for over 100 years. Many of the people that knew about the original appropriations were already long dead as of 1979. And a lot of valid water rights would have been lost in Montana without that standard because the evidence was no longer in place for people to be able to prove up those rights. So it's a really important thing to keep in mind if these rights are litigated, that the same rules apply for federal and Indian Reserve water rights as apply to state-based rights, and that prima facie standard is really key in our process.
I guess I'll just leave with a comment that, that was what my original concern was, is that these water rights have never been held in trust by the federal government, and that this compact would in fact establish that. So I'll just leave that as a concern, and I'll let somebody else ask a question.